So the race between Jacqueline Caldwell and Michael Caperton is very interesting to me because the policy that I'm looking for is essentially what are those reversible appeals. They're going to be appeals court judges, so they're going to be over the trial court. They don't retry the cases. They only find those errors in the process that didn't make the trial a fair trial. That's what the appeals court is there for. And so both Michael Caperton and Jacqueline Caldwell, they both agree that they're reversible errors. If you have a lawyer, if you have a judge that denies you of a lawyer, a constitutionally protected lawyer, when you're clearly poor. So that is, both Jacqueline and Caperton agree that essentially all constitutional rights must be upheld for Kentucky citizens, but if you're in a place, if you're accused of a crime and you request a lawyer and the judge says that you are, not poor, you have enough money to afford a lawyer, and he denies you of a lawyer, that's a reversible error. That's something you can appeal to both Jacqueline Caldwell and Michael Caperton if they were the appeals judge, and they would rule in your favor. They also both agree on hearsay. So both Jacqueline and Michael believe that if hearsay is introduced into the court and it has a substantial impact on the trial court's decision, that's a reversible error. So they both would appeal that too. Now, those are two reversible errors that they both agree on. I have been going through, there's a large body of work, because Michael Caperton was the appeals court judge for 6 years. So for 6 years he's been issuing all these different opinions, and so a lot of times it's not easy to just set a moral imperative, a rule that says that this is always a reversible error and this is always not. And so you have to look into the case law to find exactly, where those reversible errors are. Real quick, Jacqueline Caldwell said there's only two main reasons to appeal a case: because of the abuse of the trial court's discretion, or two, an erroneous finding of facts. So if the finding of facts was not correct, or if the trial court abuses their discretion, then she would appeal. So I found several different court cases, and I actually want to go explain each one of them, so this may be lengthy and boring. I concluded in another video. But I found maybe 6 or 7 more reversible errors and then 2 non-reversible errors too, or irreversible. So that doesn't change anything. It's an error, but it doesn't change anything. So, yeah, without further ado, case number 2009-CA-002343-MR. This is Thomas Norton versus Marty Perry. And Michael Caperton wrote the opinion. He reversed and remanded it. So this is reversible error. The reversible error is based upon the court's abuse of its discretion in dealing with due process. So due process is the biggest thing to get out of this. There's a lot of specifics. This is from the Fayette Circuit Court. There is property rights, the upper reaches of Boone Creek. So the National Register of Historical Places was going to try to put it under the Register of Historical Places, all this property in the upper reaches of Boone Creek. But there is a whole bunch of property owners, 100 or 200 property owners, 145 property owners. And essentially a majority of them had to object for the National Register of Historical Places to not, register that particular place as a historical place. And I believe that they did, but they didn't do it right, or they did. So due process is essentially Thomas Norton versus Marty Perry, the case. In that case, Michael Caperton says that based upon the court of abuse of its discretion in due process, he reversed and remanded that trial court's decision. Now again, Michael Caperton is going to issue an opinion for case number, or appeal number, 2010-CA-000295-MR. So Michael Caperton issues the opinion, reverses and remands. A reversible error had happened when the public attorney testified against his own client in court. So this gets pretty dicey. So you got Jose Gonzalez, and Jose Gonzalez went ahead and agreed to a guilty plea for 1 count of assault in the second degree, 1 count of wanton endangerment in the first degree, 1 count of alcohol intoxication, and he got 6 years sentenced to go to jail. So for a second degree assault, wanton endangerment, and alcohol intoxication. So Jose Gonzalez versus the Commonwealth of Kentucky. Jose Gonzalez had argued that he had conflicted counsel during his hearing. He wanted to have a motion to withdraw his guilty plea in violation of the 14th Amendments to the U.S. Constitution in Section 11 of Kentucky Constitution. So Jose said that he was innocent, and Jose had said that he understood the judge, but he didn't understand his counsel, but I think it's his public attorney. And so he thought that the plea verdict that he had accepted would get him out of jail and off probation, but neither one of those things had happened. So the judge, to clarify what was talked about between his counsel and Jose Gonzalez, he ordered the public attorney to testify what she knew and what she didn't know. And the public attorney said she didn't say that he would get out of jail or out of probation, that essentially he's making it all up, and that she said that he could go to trial if he wanted to, so she explained it all to him. Now, the reversible error, the reason why this case is going to get flipped is because the public attorney testified against his own client in court, or his counsel. I'm assuming it's a public attorney. Because if you paid for a lawyer, why would they testify against you in court? So that just sounds like a judge, an overzealous judge, just being like, all right, get up there, public attorney, you tell me what happened. So what Michael Caperton had decided was not to vacate the guilty plea, but to do a redo with new counsel and a new evidentiary hearing, so he could go ahead and, enter the correct plea. So this was a reversal. If your public attorney or your own lawyer, for that matter, there's in there a confidentiality between lawyer-client. But if the judge calls your lawyer to testify against you, you can reverse that decision. Case number 2010-CA-000402-MR. You got the Felties versus the Pettys. William and Linda Felty versus Fred and Roseanne Petty. Caperton wrote the opinion, reversed and remanded. He said that a new planning and zoning law can't disturb anything built previously, especially more than 10 years prior. There's a lot of questions of due process with this case, but this was out of Greenup Circuit Court, and there was a summary judgment that said that the Felties had to remove their carport, and that it violated the 5-foot setback ordinance of the city of Flatwoods. So the city of Flatwoods said you had to have, everything 5 foot setback off the edge of your property, and the carport did not meet that regulation. However, the Pettys had said that the Felties, the Pettys were the ones who were being petty, so they lived up to their name. The Felties said that the carport had been built 10 to 12 years prior. So a new planning and zoning law can't disturb anything built previously, except or especially more than 10 years prior. So just because someone passed a planning and zoning law, that doesn't affect the current, setup, especially if it was built 10 years prior. So now everybody has to spend money to undo what has already been done. So the Pettys said the summary judgment was proper. The Felties said that it was not. And they mentioned KRS 100.253 anyways. So they didn't have to remove their carport. It was built 10 to 12 years prior to the planning and zoning law. There was a footnote in the Felty versus Petty's case that a private party can sue in order to get a public law acknowledged. So that was Crump v. Perryman. You can file a civil lawsuit because of the criminal statutes not being lived up, not being honored.